So let's go into the sidebar, the council and I, and we'll discuss what we need to.
One moment, Judge.
Do you want to?
Yep.
Go ahead.
Okay. So one of the things I wanted to do is, at this point, we're going to also have the attorney discussions and decisions. We're going to take a break. So, Judge Hastings, you weren't going to have them exercise peremptories immediately, were you?
I was going to. Is that? Do we want to take a break right now?
I think what we thought we would do right now is actually have the attorneys meet with their consultants and actually discuss their strikes, and then we would bring them back and you would discuss the strikes with them. So I think if we take a break at that point.
We're 5 minutes ahead of time right now.
Yeah, I think we're in good shape. So at this point, I think for also the viewers out there, well, we want to show you something obviously you wouldn't necessarily see in a trial, but there might be a break. Sometimes, obviously, you're asked to do your peremptory strikes immediately. But for our purposes here, we wanted to show you how attorneys who wanted to confer with their clients or their consultants on a break would then discuss that with them. So we are going to take a short break right now, but I think Jillian and Lisa are going to be discussing on camera, and then Dan and Ron are also going to be discussing their strikes. They may not be on camera, though, and then we'll come back in about 10, 15 minutes or so. Okay?
Okay.
Thank you.
And Judge, you need to actually turn off your camera too at this point.
I was just doing that. There you go.
I can't hear Lisa yet.
Lisa, you're still unmuted. Nope, still can't hear you. Nope, still
there we
can't hear
go.
you.
Now I've been unmuted. Can you hear me now?
Yes.
Okay, perfect. Sorry about that. That was my fault. I am not a tech consultant.
Paul Sanders should not be in our breakout room.
Yeah, Paul, you are not to be logged on at this point. Thank you.
All right. Now that nobody can hear us.
Yeah.
Yeah, we were talking about in an actual online trial, I would want to do this on a different platform just so that that couldn't happen. But in this case, we want everybody to be able to see it. So we are sticking with all of you. So hi, Jillian. All right, by the way, I just want to explain something also to you and to the panel and to the viewers. The judge brought in the jurors in sort of a random order. We're going to strike basically in reverse from the last panel forward. So, Jillian, let's start with the jurors from the end of that group.
Okay.
So that last panel first.
So how do you usually do this, master jury consultant?
It would depend on who I'm working with, but I would say who are the people in that last panel who were reviewed? Let's start with that.
Okay.
Or do you want me to start since you were busy talking to people? I'd be fine with that too.
Yeah, I think you should start.
Okay, no worries. So number 5 worries me. He mentioned too many lawsuits. I don't think, it doesn't seem like he's super committed one way or the other, but I have a feeling he's just naturally going to flow that way. So he worries me. He's on my strike list, but I think it'll depend on how far we get, because I dislike juror number 7, who was in the first panel, far more. And so if we need to strike, if we're going to get that far, then I would rather strike her. So we're going to need to do a little bit of math as we go along and as we see the defense strikes too, because I have a feeling some of our strikes may be the same in a couple of circumstances.
Yeah, I had a question mark next to 5 because of that same reason, and then I had a question mark next to 33. I liked what he was telling me, but the only red flag I had, it was his wife fell at Neiman Marcus, but she did not sue, but nothing major. I had probably more concerns about a few others early on than him. But and then I'm curious your thoughts on 22. Do you think his experience helps us or hurts us?
That's the one that I was actually thinking the defense might strike. And if they don't, I think we have to, only because whatever his views on this case, he's going to be a big leader in deliberations. And the fact that he has experience with exactly this issue, I think he is sort of leaning in a sense that he would be critical of Walgreens and the way that they responded to this and the way that they trained or didn't train. But I am not willing to take that risk based on the rest of the panel. I think that that's a big risk. So my advice at this point would be that we'll keep going through this, but I would say we strike number 5 and we wait and see if defense strikes number 22, and if they don't, then we're going to have to save a strike for number 22.
Are we doing 2 strikes or 3?
3. We get 3 strikes. So moving backwards to the second panel, the lawyer, number 32, worries me for exactly the same reason. She's done both plaintiff and defense work, and I don't know how she's going to view the facts of this case, but whatever she does decide is going to be really, how she goes, the rest of the panel probably goes.
I agree. I had 32 as a strike. For some reason, the fact that she does both sides, but she has not done a slip and fall or a trip and fall, there's probably a reason for that. So I had her on my list.
All right.
And then I also had 19 as, I flagged 19 because she was the foreman in her past civil trial, and they had a defense verdict.
True. Although it was an auto accident, and it could have been really different circumstances. From her questionnaire and everything else that she said, she seems more, she worries me less than number 5. So,
okay.
And certainly less than number 32.
Okay. And then going to the first page, or did you have anyone else on that second panel?
I did not. Did you?
No.
Okay. On the first page, unfortunately, I've got 2 strikes on the first page, but I think we're not going to get, one of them is number 1, and I don't think we're going to get to her. So if we get to number 7, she is my strike on the first group.
The judge already bumped her for cause.
Oh, that's right. That's right. Okay, so good.
Yeah.
All right, so let's do some math. So if we strike number 5 and assuming that they strike number 22, and I don't know if they will, but I'm figuring they might. If they strike number 22, then we go to number 32, and that would give us a panel that looks like number 1, 2, 3, 4, 5, 6, 8, 9, 10, 11, 12. Okay, and okay, so yeah, we don't get to number 1. So if you're feeling about number 19, who are you feeling less good about? Let's ask that. Number 19 or number 33?
Which panel was 33 in?
33 was
we
the
go.
last panel, the guy down near the bottom of the screen.
I wish I had a chance to ask him why they didn't sue, but without knowing that, or foreman, I don't know, what would you suggest?
I think you're right about number 19 in the sense that she's got really strong opinions. I mean, the way she told that story about the lawsuit that her family was involved in, she clearly has strong opinions and is willing to argue for them. I think it is more important to strike number 22 if the defense does not. But, so in other words, I would say your first strike should be number, and also the defense might strike 32. I think they should. Neither of us really know what she's going to do. So
Same
first,
for, yeah, 30. Well, I don't know if we're going to get to 37.
Well, 37 was in that final group, so he would be on our jury if nobody strikes him. So did you?
I liked what he said. I was just concerned with the technology issue.
Well, and we are going to have an alternate for that reason. So if we ended up in that situation, we'd get down to juror number 6, who is the retired, oh, she's bad. She's the one who, in the first panel, who said people who file these kind of suits are probably lying, and she said, did I say that?
I had her. Yeah, her questionnaire, she said her questionnaire was the worst.
Yeah.
She thought they're lying, and it's
got
their
it bad.
inattention. So I think we need to move her to above 19.
Agreed. If we are going to get there, and if 37 is in play, then we're not going to get there. Let me see. 1, 2, 3, 4, 5, 6, 7.
Guys, can you just wrap up?
Yep, we are.
We're about ready.
Richard, I want to confirm that has 37 figured out the technology issues, it will inform our strike.
Why don't we do this? Why don't we ask Judge Hastings if he can come back in the room and we can ask that question?
That would be,
And I'm going to need
that would be great.
a quick restroom
Yeah,
break before we get started.
I was thinking we probably don't want to risk his technological difficulties. I was thinking of striking him for cause on my own.
Why
Excellent. Thank you. Thank you,
why don't we also confer with Dan and make sure that while he's in, just to make sure about that. By the way, everybody, this is Ron, who's working with Dan on his strikes too. So,
Yeah, I
Judge
was
Hastings,
gonna ask
why don't you
both
go ahead and
attorneys.
discuss juror number 37?
Pardon me?
Why don't you want to discuss juror number 37 with the attorneys?
I was worried about number 37 not being able to follow the whole trial because of his technical difficulties. I was thinking of possibly striking him on my own account because of that. What do you guys have to say?
I agree, Your Honor. I think it's difficult to have it without seeing the individual, and both sides are at a equal disadvantage with that.
Dan, what do you think?
Dan, can you hear us?
Maybe
I
not.
actually don't think. Ron, can you hear us?
No, apparently neither of them can. We'll need
Okay.
to get them on.
We're technically,
All right.
because we're
All right.
still in our breakout room.
Are they
Yeah,
in
we
the
need
breakout
Dan.
room? Okay. Irene, can we bring Dan and Ron into the Judge Hastings room?
Yep, one moment, please.
Dan, can you hear me? Oh, Ron, apparently not. We still have you, Lisa, don't we?
You do indeed.
Oh, okay. And we have Jillian.
And we
For
have,
those of you who are watching this right now, this is obviously one of the issues that we have to work out in a courtroom, which is obviously the ability of clients to confer with their attorneys on breaks, and especially when it comes to dealing with important issues like peremptory strikes or motions, or especially things like this. So so right now, Dan, can you hear? And Ron, can you hear yet? No, they still can't hear in this. All right.
Hi, everyone.
One of the issues.
Yes, Irene, Dan, and Ron are still in the sub-conference, so we're moving their lines now. One moment.
Okay. And for those of you who are watching out there, this is one of the concerns that actually has been voiced to us about criminal trials especially, which is the ability of attorneys to be able to confer with their clients meaningfully, especially regarding plea deals, regarding consequences, and things like that. So this ability to also have conferences with clients as well as then being able to communicate with the court is one of those significant technology issues that we do think that the courts have to work out.
Ron and Dan, can you hear us now? Nope.
Clearly not. Okay. I mean, ideally, depending upon the timing of this, we may say this. I mean, obviously, Judge Hastings, it's in your sound discretion to make judgment calls regarding particular cause challenges. So you can do this. Irene, are we going to be close on this, or should we move on?
And then, of course, we're going to have Ron and Dan discuss their peremptories too.
Well, I think what we're going to do because of time, because we do want to get to finalizing the jury and then having opening statements, for our purposes of the audience, we only wanted to show one group sort of discussing, just to demonstrate this is what a client attorney conference would be or a consultant attorney conference would be. So, Ron and Dan, are you still on now?
Yes. We had it dialed back in.
Go ahead, Your Honor.
Okay, what I was discussing before you guys got back on, I'm thinking of letting number 37 off for cause, mainly because of the technical problems he's having. I think that if we were to get him in the jury, we can't see him, number one, and he seems to have audio troubles as well. Any response from you, Dan?
That's fine. We were going to let him go for pretty much the same reason. So if you want to do it, go ahead.
Well, I don't want to take a peremptory away from you. No, I'm going to exercise. I'm going to exercise my discretion, and I'm going to strike number 37 for cause based upon technology issues. So
very good.
We stand now at that point where are we going to want to go ahead and exercise the peremptories?
Yes, go ahead and start exercising peremptories.
Okay, plaintiff has the first.
Plaintiff would like to strike juror number 5, Your Honor.
Juror number 5 is stricken. Okay, it's now to the defense.
Your Honor, the defense would request that you thank and excuse juror number 10.
Juror number 10?
Yes, juror number 10.
Okay, that's the researcher. Okay. Okay, it's back to the plaintiff.
Plaintiff would like to strike juror number 6.
Juror number 6 is stricken. Back to the defense.
Your Honor, the defense would accept the jury as presently constituted.
Okay, so that means it's back to the plaintiff.
The plaintiff would like to strike juror number 32, Your Honor.
All right, where did I put juror number 32? Oh, okay.
The lawyer.
Yep, the lawyer. Okay, it's back to the defense.
Your Honor, the defense would accept the jury as presently constituted.
Okay, we have the jury then. So are we just going to go with like juror number 1 was in, are we going to just start counting who's left in the first and second box until we get to 15 jurors?
Your Honor, we exercised our strikes in reverse order. So in other words, we would start with the final panel, juror number 33, then 26, then 40, and 38, and 22, then 27, 23, 24, 19, 21, 15, and 13. Is that right?
Okay, so are those the ones that are on the jury?
11, 12.
That is
12.
correct.
That's correct.
Okay.
And then
And an alternate?
would be number 9.
Okay. Very good. So should I bring the jurors back and tell them who's on the jury? And or do we want a short break here before we have opening arguments?
Well,
We have
why
plaintiff's
don't we
opening
do
statement.
this?
We're
Why don't-
scheduled for
why don't we
12:45.
bring the jurors? Right. Your Honor, why don't we bring the jurors back in, tell them who's on the jury, and then when they're then divided into their separate groups, then we take a short break while the attorneys set up for their opening statements.
Sounds good to me.
And
Okay.
I think, Your Honor, the attorneys might need a quick break as well if they haven't had one yet.
Well, yeah, when I do take it, after I swear the juries, we will then take, what, a 10-minute break? Is that sufficient?
Sure.
Okay, we will do that. So we'll bring the jury back in, tell them who the jurors are. I can then swear them, and then we'll take a break.
Sounds good.
Thank you,
One
Your
moment,
Honor.
everyone.